What are the 8 ways that your agency arrangement with a real estate broker can end under California law? When I say real estate broker, I also mean real estate agent. A real estate agent should be working under the supervision of a broker. So just as a reminder, what do we mean when we say agency? We talk about the ways an agency can end. An agency is a legal arrangement under California law where essentially your interests are being represented by a third party. Okay, in this case, it would be the real estate broker that you hire. Just as a reminder, how should you start that agency arrangement? That should always be started in writing with a contract, right? With a written contract. I've got some other videos that talk about that. So why is it important then to understand, once you have that arrangement in place, how the agency with your real estate broker will end? It will end at some point. You want to understand the way that happens. We're going to talk about 8 ways in this video. But why is it important? Well, one reason it's important is if you terminate that agency improperly, there can be financial consequences for you. Real estate brokers don't want to get cheated out of their commission. If they've faithfully represented you and carried out their duties, you owe them that real estate commission. And so you want to be careful about how you terminate that agency relationship. The other reason is real estate brokers and agents only owe you their duties while they are your agent. So you need a clear understanding of when that agency ends, because once that agency ends, they're no longer representing your interests, and you want to know that. And then the third reason is once the agency ends, if there's problems with the real estate parcel that you bought, you're on your own. As a general rule, if you call your real estate agent or broker for help after their agency has ended, they're probably not going to answer your phone calls. And so I often find that clients call me when they're in that situation. They've bought a piece of property, they didn't get a survey, now there's a problem, and their real estate agent says, I can't help you. You need to call a surveyor. So then I'm on the phone with them. So that's important. So under California law, there are 8 ways to terminate a real estate agency. Okay, one is the term expires. So if you have a contract to be represented by a real estate broker, there should be a date where that contract will automatically expire. So that's called expiration of the term. If the contract becomes impossible to fulfill, that's called extinction or impossibility. So for example, you hire a broker to sell your house, and your house gets destroyed in a hurricane. Your broker is probably going to get out of that contract. If the real estate broker or agent dies, or you as the client, or what the law calls the principal, die, so death can terminate the contract. Renunciation of the contract, so if you can renounce the contract with your real estate broker, or they can do that with you. As we mentioned, there could be consequences to that, but that's basically when you terminate the contract in writing. If the agent or the principal, maybe they don't die, but they become incapacitated. So if I get in a car wreck and I'm in a coma, that's probably going to terminate the contract with my broker. The 2 parties, the real estate broker, agent, and the principal or the client can agree, so it can be done by mutual agreement. If the real estate broker or agent fulfills their contract, so you hire them to help you buy a house, they help you find a house, you sign the contract for the house, you buy the house, you pay them their commission. They can say, hey, my obligations under the contract were fulfilled, so that can terminate the contract. And finally, if somebody goes bankrupt, so if either the real estate broker or you as the principal go bankrupt, that can terminate the contract. So as I mentioned before, if you're going to renounce or terminate that contract unilaterally with your real estate broker, you need to understand that there's consequences. You want to make sure that you deal fairly with your real estate broker or agent. You may owe them for some or all of their commission, depending on the circumstances. So make sure you read your written agreement that you have with your real estate agent or broker and understand what's going to happen if you unilaterally terminate the contract. If you have an agreement to be represented by a real estate broker or agent, make sure that you put that in writing. That's really important. If you're going to terminate that agreement by mutual agreement, you should also put that in writing. That termination should be in writing. It could be simple, it could be a 1-page letter, but the parties should do that. Both should sign it. And then if you're going to allow your real estate agency contract to be terminated by full performance, make sure you and the broker both understand what that means. In other words, you don't want there to be a misunderstanding between when the real estate agent thinks their job is done and when you think their job is done, right? And usually real estate agents are going to assume their job is done after the sale's closed and you've been given the keys and they've been paid their commission. So if you don't think that's the end of the deal, if you expect more than that, then that should be very clear and it should be put into your real estate contract. So it's important to have a written agreement if you're going to be represented by a real estate broker or agent, especially in a commercial real estate transaction. And you want to understand the proper way to end that contract. If you don't, there can be severe consequences under California law. Don't mess it up. Get everything in writing. Make sure that you're fair and make sure that both you and your real estate agent understand how that relationship is going to end ahead of time.